handling a bench warrant, the steps to take in Oklahoma. I'm Tulsa Attorney James Wirth, and if the bench warrant is issued, what do you need to do? Well, a lot of times it depends on the type of bench warrant that you're dealing with. So there's a few different types. You could just have a criminal case where you've got fines and costs that are owed, and those aren't paid when they were supposed to be paid, and you could get essentially a failure to pay warrant issued. So how do you handle that? Well, best case scenario, you can get the funds together to cover that, and you can essentially purge that by getting that paid and make that warrant go away without you having to be processed and being arrested. To be safe, a lot of times it's best to get that money together, have somebody else run down to the courthouse to pay that for you, so you don't risk getting arrested while you're trying to get it resolved. But in either way, you want to get it resolved as quickly as possible, because if you get pulled over for a traffic stop, they run your name, they're going to see there's a warrant, they're going to come pick you up, and take you into custody. It's unlikely on a failure to pay that they're going to send a bunch of law enforcement to get you, but if somebody, in power doesn't like you and is out to get you, that can be grounds to do so. There's nothing to prevent them from coming and picking you up on a failure to pay warrant, but most of the time they don't put a lot of resources into it. They wait for you to come to law enforcement through a traffic stop or elsewhere, or they wait for you to purge it. So if it's failure to pay, try to get it purged as quickly as possible. The other one is a failure to appear. So if you have a traffic ticket and you don't pay that, or it's one where you have to show up for court and you don't show up for court, then they're going to issue a warrant for your arrest, depending on what the severity of the type of case it is, the type of citation, what court it is, and you may want to handle it differently, but that is probably one you want to talk to an attorney on. If it's in, say, Tulsa Municipal Court, most of the time we can add that on, get the warrant recalled, and then we can start to try to work out a deal to get that resolved, so it's not too tough. Now, if you try to do that on your own, it's a little riskier, because you go down there on your own, start talking to them, there's an open warrant, you could be arrested and processed on that, but most of the time it's not too difficult to deal with in municipal court. In county court, it can be a little bit more difficult, but if it's just a traffic ticket, you want to try the same thing. See if you can retain an attorney. The attorney can negotiate on that. If a deal can be entered right away, then by resolving the case and getting a final resolution there, that kind of makes the warrant moot and get that recalled and get that done. But if we're talking about a failure to pay on something more serious, like you get arrested for a misdemeanor offense or a felony offense, you bond out, you promise to appear in court, and then you don't, that's going to be a problem. It's very typical for the court at that point to triple your bond. So if you've got a bail bondsman and they triple your bond, that bail bondsman is no longer going to help you out, and the bail bondsman is not going to be very happy that you failed to appear and is going to be looking for you to try to get you to turn in, so they don't have to pay that money to the court that they promised to pay if you failed to appear. If you have a cash bond, then it's your own money that's potentially lost. But in any case, whatever you paid, it's pretty common practice to triple that. So what do? Obviously, you're going to need an attorney. You get an attorney like us in the case, we're going to want to coordinate with your bail bondsman. So if we contact your bail bondsman quickly enough, you forgot your court date, something came up, you were in a doctor's office, you were hospitalized, you were being held on charges elsewhere, we try to explain that away first to the bail bondsman to see if they will re-endorse for you if we can get that bond lowered back. And then we would take you before the court, essentially turn yourself in, not to the jail, not to the police, but to the court. If we're quick enough after that failure to appear, a lot of times we can get the court to agree, hey, there's a mistake, you're turning yourself in, you didn't have to come get him, we came to you, can we get that original bond reinstated? So if it was $3,000 and was tripled to $9,000, can we get it back to $3,000? And then we coordinate with the bail bondsman, have that person there as well, see if they will re-endorse on that same amount again. A lot of times they'll charge you just essentially a processing fee, maybe $100 to do that. Sometimes though, they won't. They say it's a whole new bond at that point. At that point, it doesn't sound like they're working with you too much. You might want to use a different bail bondsman at that point. But again, if you fail to appear, they're not going to be too happy, but it depends on how much time has passed. So that's your failure to appear warrant. The other ones that we have is an application to accelerate or an application to revoke. So here you've got a criminal case. You work out a deal where you're put on probation, either on a deferred sentence or on a suspended sentence. You're on probation, but they're alleging that you violated that probation. Maybe you got picked up on another charge. Maybe you failed to appear to pay your fines and costs. Maybe you failed to pay your restitution, failed to pay your supervision fees. Anything along those lines, failed to do drug testing, whatever's ordered for you, you failed to do it, they file an application to revoke or accelerate, give that to the judge, and a warrant issues on that. Most of the time on those warrants, they're issued without any bond, so you can't just get a bail bondsman and bond out at that point. So most of the time you want to coordinate to have a bail bondsman present, turn yourself in with an attorney so that attorney can try to negotiate to get a bond put in place. Sometimes though, they'll hold you on that for a few days, almost as a punitive measure, although technically maybe it's not supposed to be punitive until you actually have a finding that you violated probation. But it is common practice, set it at a zero bond, you're behind bars for a bit before they set another bond for you at that point, but definitely want to get an attorney there. All right, then the last one is we're talking about a new case. So you've got a brand new case. So this is not where you're arrested, but maybe an investigation is done and they file an affidavit for an arrest warrant and an information where you haven't previously been arrested on it. So at that point, you may get advanced knowledge of it. You can check it perhaps on OSCN, see what the bond is set at, if it's set pursuant to the bond schedule immediately, or if not, then it'll be set for a determination of bond once that warrant is recalled or resolved. So if it's a new case, obviously get an attorney. That attorney can recommend a bail bondsman. If the bail's already set, you can get that worked out with the bail bondsman. It's essentially doing a walkthrough with the bail bondsman where you turn yourself in, they do the fingerprinting pictures that they need to, and have you in and out hopefully fairly quickly. So those are the types of warrants and how to resolve them in the state of Oklahoma. But if you're dealing with a scenario, like I said, on most of those, you really do need to talk to an attorney. So if you're in that circumstance, go ahead and talk to an attorney. Go online to talk to an attorney in my office. Go to makelaweasy.com.